decide how to develop it, how to buy it, how to use it, how to invest in it. How do we get organization to do it in a way that promotes AI responsibility? So that's what I do. And today we also have Ray's son, who is, hi, Ray.
I love it.
So Ray is a technology lawyer specializing in AI, but also he's an AI developer, which is super cool. He is based in Australia, but he deals with AI laws worldwide, which is why it's so cool to get this opportunity to chat with you today about the EU AI Act. So, with that being said, why don't we just kind of jump in? So the format for today is just kind of a conversation. So it's not meant to be a talk. We haven't made a deck. We're not going to really present anything. We're just going to have a conversation with one another, and also anyone who wants to have a conversation in the Zoom chat. So feel free to put your questions into the chat.
Oh,
Yeah, put your questions or comments into the chat. Then we'll go through them and we'll invite the people who have written certain comments to chime in if they want to. Also about the format, some are joining us through Zoom, some are joining us through YouTube. We're only able to see the questions of people who are joining through the Zoom link. So if you hear me and you're on YouTube, please join the Zoom if you wanna write your questions. So, okay, now to the EU AI Act. Why don't we start with something general? I'm just going to ask Ray, and anyone in the chat can write your questions, please. So, Ray, I'm just curious to hear your general thoughts about the EU AI Act as a technology lawyer.
yeah. Well, yes, really, really keen and really happy that this is finally happening. So, yeah, as Ravi mentioned, I'm a huge I love studying AI regulation, and the EA Act is something that I follow really closely. And yeah, I thought the EA Act was a pretty textbook and very GDPR styled approach to regulating AI
Did you
with
say
many
PR
ex
style
ante.
approach? Sorry.
We can talk about
Okay,
this.
I
We can
just
talk
wanted
about this a
to
bit more
go
in depth.
ahead.
Yeah, yeah. But I thought it was a very had a lot of ex ante requirements. So it had a lot of obligations around trying to prevent harm before the harm even occurs, and has a very strong sort of approach to encouraging strong public enforcement of hefty fines. But I do have some questions around whether these are practical and whether they can be enforceable in practice. And there's also a lot of reliance on external standards and benchmarks, which have yet to be confirmed, or they're situated in another regulation which can be subject to change. But overall, I thought the UA Act was a pretty sensible starting point, and I'm sure it'll be retested and will be refined over time.
Okay, yeah. So I'm really curious to hear about what did you mean by this PR approach, because I think that's a really interesting observation that I haven't heard before. What do you mean by that?
Yeah, so a lot of people say that the EU AI Act is kind of following, in a way, the footsteps of the GDPR. So the GDPR, for those who don't know, it's the European Union's flagship regulation on privacy and data protection, and it's often considered the golden standard for privacy law in the world. The GDPR has quite strict and quite high standard obligations, restrictions around how you process data, and a lot of businesses who want to basically comply with everyone in the world choose to often comply with the GDPR first so they can basically be compliant with everyone else in the world. That is kind of what I'm seeing the EA Act is trying to become, to be like the high watermark, the high golden standard for AI regulation, and for other countries to, in a way, follow that. And actually, the EU has inspired a lot of other countries. We have South Korea, Canada, Brazil, Peru, Thailand following the footsteps of the EU thinking. So it's something that they've definitely had some influence so far on the AI regulatory thinking.
Okay, that's really interesting. I see that we already have some questions in the chat,
Mm.
so please keep them coming. I just need to I need to follow up on something you said, Ray.
Yeah.
Yeah, it's really interesting that you call it PR and you said you mean that the European Union is trying to set a standard that will have this global effect. And I think that's such a crucial point because there is so much geopolitics behind the
Oh, yeah.
EUAI Act, right? Just like the GDPR, and the nations are kind of, they're battling for superiority and they're battling for, control as countries do, um, which I think makes it really interesting to see the pushbacks from the UK, right? They're really trying to distinguish themselves and say, no, we're totally different. We disagree with the EU. And then of course the US, oh no, but look, what about innovation?
Mm.
And a while ago, I saw an interview with, I forget who it was, but it was in the New York Times interview with someone from the US government saying something like, we want to determine our own laws, right? And I think that's something that is behind some of the global resistances that we've seen to the EUAI Act. I've also seen people trying to learn lessons from GDPR, as you say, because GDPR does have financial consequences, right? It does create an incentive for companies to put their data servers in the EU, which is, it does actually have a lot of financial consequences for countries. So I've also heard in the US people worrying about economic effects to the EU,
Mm.
which is another thing that stands behind this whole geopolitics behind the EUAI Act. And also, I may add, it's the same person who also told me that, when the person raised concerns about economic effects because of what happened with GDPR. And I said to him, well, do you think the EUAI Act is really kind of a way to exert financial control? And he said, absolutely.
Mm.
So that's a really interesting layer. And I just wanted to add that to this, what you call PR aspect, because I think that sometimes it's overlooked. Okay,
Mm.
I
Mm.
I wonder if we should kind of continue on that, or if you want to go to the chat.
Yeah, like I think just to add to that, yeah, I definitely see where you're coming at. I think the thing about AI compared to many other forms of tech and data regulation is that AI is so broad. And actually there's a common misconception that AI is actually a piece of technology. It's actually not. In my view, it's a field of science. It's a science of studying machines and how do you build machines to be able to simulate human intelligence. And the field of AI itself can give rise to so many different applications, right? So, for example, the facial recognition in your Snapchat filter is the same technology that's being used in, let's say, CCTV cameras to catch criminals and suspects. So, AI, it's such a broad field, and unlike data, where the scope is quite specific, you're dealing with pieces of information, digital form that relate to a person. AI is really you're trying to regulate a science. You're trying to regulate a field of technology. And of course, obviously, this triggers geopolitical questions, competition questions, economic questions. There's also questions around just each country's existing legal system and the existing laws. So, for example, the EU Act is rather detailed, it's very long, around 300 pages. But you have to consider that. Oh, I'll just try to mute someone. But you have to consider that, the EU is a civil law system, and the civil law systems have to have really detailed legislation, whereas other countries like the UK, Australia, and even the US are common law systems where you have the courts who can play a role in interpreting the law, which then gives rise to a different approach to how their laws are made. So my key point is that AI regulation is not just about AI and the law. It's a big picture. It's so much bigger picture than that. And I guess this is one of the things I want to get out of these sessions to really learn different perspectives from various people with different backgrounds, how they see AI, and that could help us give us a better view as to, what's the appropriate approach for each market. Yeah.
Thanks. Okay, so let's turn it over to the chat.
Mm. Oh, it's all questions
Okay.
already.
Yeah, okay. A lot of questions. Now we're gonna have to choose, which is the most difficult thing to do. Okay.
Maybe I can talk about the Petko Getov. I'm sorry if I mispronounced your name. You asked a good question around loopholes in the EA Act. I think if you want to talk about this, Ravi, I can maybe do a start. Maybe that's a nice segue into like the
Yeah,
definition of AI
yeah,
in the EA
yeah. And
Act.
I sounds
Yeah.
good. So Petco, if you're here with us and you wanna unmute and expand on the question you had written, please do that,
Sure, thank you.
or
Thank you.
we'll read
Can
it.
you hear
Oh,
me now?
hello, yeah.
Yeah, thank you. Yeah, the question comes especially from the background that I've read a lot of opinions on that. The concessions that the EU made when they finalized the UAI Act and voted on it, and the fact that there were a lot of exemptions and exceptions and whatnot in Articles 5 and 6. So I'll be interested to know what's your view on that, and do you think it will be practically then at one point very possible for companies to go around the regulation and fill in exception forms or whatever they want to do, so they're not then they won't be fulfilling the requirements because they will find an exception to the rule they fall under, for example. And do you think this will happen at a larger scale, let's say? Thank you.
I can probably make a start on this, Revit. So I can probably answer this in three ways. First, the way through the scope and definition of AI. Secondly, maybe an example of the high risk system, which is basically the key point in your question. And also third, maybe I might talk about the foundation models, also known as general purpose AI model in the EA Act. So the definition of AI system, which is the core definition in the Act, because this definition is what really drives the entire scope of the law. For those who just want a refresher on the definition, it's a machine-based system designed to operate with varying levels of autonomy and that may exhibit adaptiveness after deployment, and that for explicit or implicit objectives infers from the input it receives how to generate outputs such as predictions, content, recommendations, decisions that can influence physical or virtual environments. So I just read out the definition of the AI system. So this definition is it's adapted from the existing OECD definition of AI system. But I do have some query as to whether this definition really does the job, because as I said, AI is really broad. And traditionally speaking, when we say AI, we really mean like machine learning. Most of the apps right now in the AI space are machine learning systems, basically machines that process data, find patterns in data, and then uses those patterns to make predictions. But there's also another field of machines that are technically not machine learning, but they also have a level of automation. So, decision-making trees, expert systems, rule-based systems. You can argue that a calculator itself might fall within this definition. But the key word in this definition that I just read out is the word infers. And the word infers is not defined in the entire act, and it's really subject to interpretation. What does it mean for a machine to infer? For example, when you use a calculator, 1 plus 1 equals 2, is a calculator inferring that 1 plus 1 equals 2? And if so, can you argue that calculator is an AI system? Now, in the recitals, which is like the introductory text to the EU AI Act, they did clarify that the word infer is meant to capture stuff that's more than basic data processing. So that's another key word, basic data processing. So the calculator example might not fall within the infers sort of scope, but let's talk about more complex systems, which are not machine learning, but have very large impact. And for those based in Australia, you might have heard of the Robodebt case. So the Australian government, a few years ago, implemented an automated system that can basically detect who was overpaid in government benefits. And if they did, they will then receive a debt notice requiring them to pay it back to the government. Now, the system was flawed, its algorithm wasn't correct, and it basically ended up issuing more than like 600,000 wrongful debt notices. So over 600 people were told that they owe money to the government when it did not. And that's an example where Robodebt was technically not a machine learning system, but its algorithm was matching income data. And could you argue that is that income matching data processing or not? And it is these sort of examples where companies can really argue whether what they're creating falls within the AI system definition. So that's the one angle, the definitional scope. Maybe Ravid, do you have any thoughts on that if I go into some of the other sort of areas?
Yeah. I want to address a closely related loophole because I think you've covered this one pretty well. What counts as an AI system? Another question, foundation models, because the Act also has definitions of what foundation models are big enough. That to me is super interesting because the Act is very specific when it comes to that. However, that's related to one of the other questions here, asking about how will the Act keep up with the changing speed of reality. I've already heard of companies who are intentionally trying to stay just below the threshold of the foundation models that count for the Act. So that's another point for potential concern of loopholes, in addition to what counts as AI. Another question for companies to play with and use as a loophole: what counts as a big enough foundation model to kind of be under the law? And then I want to go back to Petko's question about the high risk systems, because I think that it is one of the biggest loopholes in the Act. What counts as a high risk system? So the European Union, I always heard them say that they think that maybe 5 or 10% of the AI systems are going to come under this definition. Ray, I see your image is frozen. Are you with us?
I am.
Excellent. Okay. So I always hear people from the European Union say that only 5 or 10% of the AI systems come under this high risk definition, which definitely even more kind of raises expectations on my part that companies are always going to try to not be a high risk company. But also maybe it's very difficult when it comes to AI to really predict what's going to be high risk. I'll give an example from a panel that I've listened to, I think at least a year ago. The panel participant was a blind person, and he was raising concerns about how do we know what really counts as high risk. And as a blind person, he said, listen, what if there's an AI technology that can improve my eyesight? That would be fantastic, wouldn't? And doesn't sound like it's something that's high risk. But on the other hand, he said, I wish I remembered his name. But on the other hand, he said, what if now it's only really available to people who are really rich, and also don't necessarily have a vision impairment. And so basically now people who have money are using it to augment their abilities as humans. Aren't we creating or potentially creating another, division between humans? Isn't that high risk? And his point was, with AI, because of how far reaching the consequences can be, it's really tough to predict what's going to be high risk. And so that's, I don't want to call it a loophole, but an issue.
Yeah. And I like how you raised the foundation models and the threshold. So just to recall everyone's memory here, the current threshold that they've set is 10 to the power of 25 floating point operations. So it's a very specific technical metric. And arguably right now, the only foundation models that hit that threshold are GPT-4, and it's yet to be confirmed on maybe the Google's Gemini model. Other models like Llama, arguably Anthropic, like other models which are very powerful for like the ordinary user, because they don't fall within that 10 to the power of 25 flop threshold, they're not considered foundation models with systemic risks. So there's that distinction. You got the general purpose AI models, and then the general purpose AI models with systemic risk, and the latter category is subject to a lot more requirements, particularly cybersecurity requirements. So normal foundation models are not subject to these strict cybersecurity requirements, but those with systemic risk are subject to cybersecurity. And cybersecurity is a pretty big deal these days. Like a lot of models are they're gonna be pretty big targets to cybersecurity issues. And also within the high risk category, there are a bunch of sort of prescribed sectors, but notably the high risk tier doesn't include e-commerce and search engines. So basically, like e-commerce and search engines are really they're platforms which have like all these recommendation algorithms, which arguably do have some sort of risk into, let's say, in terms of misinformation or influencing people's views. Now, I guess this is where the Digital Markets Act comes in. So the EU also have another piece of law that kind of deals with digital services. But this is where this is coming back to the point where you have to look at the AI Act in the context of everything. Just because the AI Act might not mention something doesn't mean it's unregulated. It might be covered under another law. So I think it's important that, whenever we look at these sort of issues, always look at the big picture. But yeah, these were some of the other points I want to mention. Yeah.
Okay. Why don't we turn back to the chat and see if we want to pick out another question? What do you think, Ray?
Yeah, sure. Yeah. Let's see. Maybe I'll check on YouTube to see if anyone's asked any questions on YouTube.
Yeah. So we don't neglect them.
Yeah. But like maybe in the interim, like the high risk applications, they're subject to registration requirements, risk management requirements, and also quality management requirements. Like maybe just because you're like a consultant in this tech space, do you have like any views or ideas of how the EU AI Act might influence the way we monitor, evaluate, or assess AI systems?
Yeah, that's a good question.
Hmm.
Yeah, I think companies are gonna wanna not be in the high risk category, whatever they can to not be in the high risk category. That might affect the framing of what they do or who they put their responsibility on, right? Because maybe they want to say like what we do, like we don't have this like use case, it's you, our customer who's using it for whatever use case. Especially as I'm seeing so many companies who are saying we just help clients create their own technology, but we don't really create the technology ourselves. That kind of makes me think that they're gonna want to push the responsibility onto others and kind of not do it themselves.
Yeah, yeah.
Yeah,
And
yeah.
responsibility is that's a pretty tricky concept in the EU AI Act. Right now, most of the obligations are put onto the provider of an AI system. So and what they mean by provider is basically someone who puts an AI system on the market. So provider is not limited to a manufacturer. You don't have to be a manufacturer or developer to be a provider. As long as you're, putting on market an AI system, you're a provider, and then you're subject, depending on the risk category, to all these obligations. But the EU AI Act does have some provisions that kind of deal with when that responsibility passes on to another person down the value chain. And this is where like the concept of when does a deployer, so a deployer is basically a user of an AI system, when does a deployer become a provider in the value chain? And so far, the EA Act has a threshold test called substantial modification. So if you're a deployer who makes a substantial modification to an AI system, then you become the provider of the AI system, and then all of a sudden you have to comply with any relevant obligations. And how they've defined substantial obligation is when uh, let me just quickly find the wording of that definition. Um, it's basically when you really change like the purpose or you make a significant like change to the AI system. So, but the thing about the substantial modification threshold is that it only applies in the high risk system category. There is no equivalent definition in the foundation models regulations. And that's what I find is probably one of the big gaps in the EU AI Act, because in the general, foundation models are meant to be used by a lot of people, right, for general purposes. That's why they're called foundation models. But the EU AI Act isn't really clear as to when do the obligations of foundation models pass on to a user foundation model. Now they have the concept of significant change, but it's not doesn't have a formal definition. And actually, when I read through some of the updates, the previous versions of the EA Act did have some sort of change mechanism around foundation models, but they since removed it. I'm not too sure why, but that's one of the uncertainties in the act that I found was pretty not problematic, but I thought was needed more clarity. Maybe that's where the subsequent sort of like benchmarks and technical standards will come in to clarify, but I thought that was something to make note of. Yeah.
Yeah. So really, yeah, this is such a good point because I think it points to another potential loophole. Who is a
Mm,
provider? Who is a deployer, right? So I think what we're saying here, maybe, in different ways, I think one of the responses in the market is going to be people trying to avoid responsibility by utilizing loopholes like this, right? And saying we don't actually count in the category of people or companies that need to do anything.
yeah.
Yeah. Okay, I
And
want to maybe, oh, sorry.
oh yeah, I just thought like speaking of loopholes, it's also good to talk about where the AI Act might overextend to use cases that might not be fit for regulation. And this is where I can talk about the extraterritorial application of the EAA Act. So under Article 21A and 21B, the act will apply to providers regardless of where they're situated who place an AI system on the EU market. And this is where I find very interesting, and this is where I find the difference between the EAA Act and the GDPR, that difference. So in the GDPR, it applies also to people outside the EU. But the key, I guess, threshold is if you're doing business in the EU and you're processing EU citizen data, that's where the GDPR applies to you. But the difference in the AI Act is that it's not fixed to a person doing business in the EU. Rather, the threshold is based on where the output of the AI system is used in the EU. And that is a huge difference because let's just say I'm developing an AI system, only want to target the Australian market. But let's just say my AI system produces an output and that output ends up somewhere in the EU. Does that mean I'm now subject to the EU AI Act, even though I never wanted to be in the EU market? But solely because my output's being used in that market, does that mean I'm now subject to that? And so I think that's one of a few commentators have raised that, and I'm not too sure if there's much, I guess, clarity or discussion around that. It could be something that I don't know, might be clarified in further explanation or recitals or whatever. But I thought that was maybe if anyone had any thoughts on that, they could share in the chat. Yeah.
Yeah. I wonder also what does it mean, to have the output used in the EU? Like, for example, suppose I developed an LLM that produces texts,
Mm,
and then the texts end up, on some website and someone in the EU reads it, right?
yeah.
Does that
Like
count?
I read the recitals and the actual wording is like where output is produced by an AI system is used in the union. And when you look at the recitals, that recital paragraph number 22, which explains that, all it just says is that output produced by those systems is intended to be used in the union. So I guess the keyword is intended. There's an element of intention, but that is a recital paragraph only. It's not an actual like legal sort of codified within the actual body itself. So we're really relying on the recital trying to clarify things here.
Mm,
But yeah, I don't really have an answer to that. I,
yeah.
I just thought that was something interesting to raise. Yeah.
Yeah. Which is all of those potential loopholes and confusions, I think they also in maybe signal to us that we're going into a period of confusion right now because the act, as you said at the
Mm,
beginning already, still needs to be clarified in many ways. It refers to standards that haven't been written yet, not to mention all these questions. And yeah, I think we're headed into a period that one aspect of the future that I guess we are anticipating is like one, companies trying to avoid having to have any responsibilities, and second, a lot of confusion about what certain sections mean. And when I think of this combination of confusion with companies trying to avoid responsibility, lobbying, I think, is a consequence of that,
mm,
right? Companies also trying to influence the shaping of those standards so that they don't have to do too much, which I think going back to one of your comments earlier, Ray, about how some of the bigger models, foundation models today, like Llama, somehow fall beneath the threshold of like a big, large language model. I don't think that's a coincidence. That would be my guess, that some lobbying has happened here in the
Yeah, well,
background.
yeah. To be clear, there's still, I think there will still be like considered a general purpose AI model in the act. It's just whether they're considered systemic risk models, which would then be subject to further requirements. So yeah, just to clarify that what that
Yeah,
threshold
thank you
meant.
for that.
Yeah.
Yeah. So it's interesting that they would fall beneath the threshold of what would require kind of more of them. Okay,
Yeah.
I wanna segue us a little bit to the day-to-day practicalities of the EUAI Act. Is that okay for you, or do you want to discuss something else
Yeah.
first, Ray?
No, let's go into the practicalities. Yeah,
Okay,
we're halfway
I
already. That's good.
I am super interested in the topic of procurement, which to some, including my past self, might feel boring and great, but actually, I think that that is one of the most interesting places for AI and AI responsibility, because most companies are not going to develop it themselves. Most companies are going to buy it from someone, and it is within procurement that you decide who's responsible for what, and also how you're going to enforce that responsibility. So I'm really curious about the impact of the EOI Act on procurement processes and contracts as a part of that. And then Ray and I, of course, this is not the first time we're chatting in our lives.
Yeah.
When I raised this topic of procurement and procurement contracts in particular, you said, Ray, well, actually, there are other kinds of contracts that are influenced by the EUAI Act. So I would just love to hear your take first on procurement contracts and then other kinds of contracts.
Yeah. Well, I think I think where the EU Act might have an immediate effect. So again, the EU Act is not enforced, so I could be wrong here, and we don't know what actual impact it might have. But just looking at the text, I can predict there being three key sort of not issues, but three key areas that suppliers and customers might start to kind of question. So number one is really around compliance with law sort of warranties. So it's quite standard for contracts to include, let's say, a warranty that says, supplier will comply with all laws or all applicable laws. And sometimes this sort of phrase just gets thrown around pretty casually. It doesn't really it's pretty like, oh yeah, we'll just do that because it makes sense. But now with the EA Act, once this is in place, like it might be, I think parties might be more, I guess, discreet, and they might be more cognizant of whether they want to they won't be more careful when they put down compliance with all applicable laws, because with the EA Act, many areas have yet to be tested. You don't know if you can afford to just, I guess, blindly comply with it if you don't really know how it works. So I feel like there might be a period where businesses will kind of carve out or negotiate that sort of obligation slash warranty. And there's also you have to also be mindful that the high risk AI system obligations only come in 3 years after the AI Act comes into force. So you have a 3-year transition period. And I can see that practically in those 3 years, there'll be a lot of, I guess, emerging contract standards. So the AI Act doesn't really deal with contracting, because contracting is really a private to private sort of matter. But I can see there'll be like standards, templates around this. So that's one. The second one is around documentation, and this might sound like a boring topic. But records and documentation will be right now it's pretty underrated, but it will be such a pretty big sticking point once the AI Act comes into force, because again, think about big picture. So in addition to the EU AI Act, there's also the AI liability directive, which is basically a directive that deals with how AI related litigation is going to be dealt in courts. And one of the key principles being established under that is around the presumption of like causality. So basically, if let's say a provider breaches their obligation under the AI Act, if as a victim you're able to prove that that action influenced the output of an AI system, then the court can then presume that the output of the AI system caused you damage and loss, which is huge because proving causation in litigation is often in many cases, it can be quite a difficult issue, especially if you can't really. And actually, the key challenge for a victim trying to do that is they don't have the actual documents and the records to kind of prove that. So, in order for that liability directive to actually really help victims, there need to be some sort of fair exchange of documents and records between supplier and customer for that liability directive to be effective in practice. And so I can see in this near future, a lot of customers who really need who are buying like high risk systems really want to like I can see them, probably adding obligations and a lot of like I know they might push for like documentation and record keeping and being able having the right to request to see those records, which is obviously a hugely in contention with the supplier's rights because supplier wants to keep their trade secret. They want to give away information and have to. So I can see documentation being what's a boring area becoming something that's going to be hotly negotiated down the track. And then the third issue is really around just the general stuff around liability and indemnities. Indemnities and liability are often always going to be negotiated anyway, but if the subject matter of a contract, like if the AI system is going to be subject to an AI law, the parties might enter into negotiations around whether the vendor should indemnify the customer if they breach, the AI Act, whether that's going to be something that's going to be hotly contended as well. Yeah, those are the other things I can kind of think of from the top of my head, in terms of how this might affect day-to-day procurement. And also, actually, another thing is like also just a lot of like due diligence. Due diligence would be a huge thing. And especially for importers and distributors, I feel like these are another two sort of groups of people that would be subject under the AI Act that not many people talk about. So importers and distributors will need to carry out verification checks on the provider. So if you're importing an AI system or you're distributing an AI system, you need to be able to verify that the provider complied with a bunch of conformity assessments and they've got the relevant documentation processes. In other words, it's going to be a huge verification due diligence exercise for importers and distributors. And that could then increase compliance costs, but it also might create a lot of opportunities for auditors, consultants, etc. on that. So it might be a good and bad thing at the same time. Yeah.
Yeah. I love your point about documentation
Mm,
because the way I'm hearing it, you're saying there's going to be documentation wars because the
mm,
buyers are going to want those documents so that they
yeah.
can have, those proofs for liabilities, but the sellers are not going to want to provide that because they don't want this liability burden.
Mm,
It's interesting because I think that already there is this phenomenon in the AI ethics space of insufficient documentation on everything related to AI ethics or AI responsibility when on the one hand, companies are putting out so many policies, frameworks, best practices, how we move to action in AI ethics. Most companies have something like that. Most big companies have that. However, most of those documents are not really indicating any kind of action. And I'm saying it because I've actually done a research project on this where we studied 254 companies and the public information they put out there about their AI ethics practices. There's not a lot about what they do, even though it doesn't pertain to any kind of trade secret. So I was only looking for things that are about governance, like do you have an ethics team? Do you do any best practices like red team, whatever. It's not a trade secret, and yet they don't really divulge that information. It's not an accident that they don't. So I'm already seeing this phenomenon out there, and yeah, perhaps it's going to become even worse because I mean, on the one hand, they will have more pressure to show that they are acting responsibly because of the higher expectations, especially in the context of important of importing or other due diligence processes. On the other hand, they're not going to want to have any substance in those documents because of the liability. So maybe there's a risk here that we will have more of those documents, but more chance that they're going to be vacuous.
Yeah.
Yeah, which is, I've been thinking a lot about what can be done to combat this phenomenon, especially when I think of like standards that are taken seriously or regulation. And I've been already thinking for a long time that we need more robust standards on transparency on the governance activities alone, right? Because they can't hide behind IP when it's about the governance. And this kind of just makes me think more that what if it was actually required of companies to tell us exactly about their efforts? You know, how many people do they pay to do specifically things related to AI ethics? Do these people have like the right kind of training even? The answer is often no. But anyway, I just wanted to emphasize this point about documentation. But I saw some questions in the chat that were kind of intriguing to me. Do you want to do that, or do you want to continue on this turn?
I think while we're still on that, I might just quickly address a question on the YouTube live stream, give some attention to the YouTube side. So Suburban asked a question around who owns the IP in like, AI created tools and AI created output. And I feel like this is something I want to kind of briefly address because the EU AI Act doesn't really deal with IP issues in AI. And when I say IP issues, I mean, for example, the issues of like, do AI developers have the right to use copyrighted information to train the AI models, even if that information's on the public internet? Also, who owns the output of an AI system? Like, who owns AI generated output? So these are questions which are still being hotly debated in the academic space. And I can understand why the EU AI Act might not address this directly because there are already existing IP laws in there, which might be better positioned to deal with that. But the one key IP related thing in the AI Act is around a general purpose AI models. If you're deploying a foundation model, you have to provide like a summary of all the copyrighted sort of material that you use to train your model. And it's not this type of provision doesn't again address copyright issues, but it does add to the transparency element, which is coming back to this discussion here, right? Transparency. But I can see on the contract level, when businesses do contracts to each other, there's still a big gaping issue around IP. Like, can a supplier warrant to the customer that they got all the relevant IP rights and licenses in the AI model that they're selling to a customer? And also, are they going to be able to indemnify or compensate the customer if a third party sues the customer for IP infringement arising from the AI system? And right now, like there is really no clear approach to this, at least in law. The market standard right now that I'm seeing among like the big tech companies like Google, Microsoft, Adobe, and what else? Amazon. They're only providing defense obligations. So they're only promising to defend the customer if there's a third party IP infringement. But a defense duty is not the same as indemnity. Indemnity is where you compensate them directly, whereas a defense duty is you accompany them to court, you fight the battles together in court, then they'll pay you your costs. So there's a bit of a journey there in a defense obligation. And yeah, it's something that's a bit it's something that even the big AI developers companies are still trying to work out what's the best way to balance that. And that also then kind of gives rise to competition questions. So if only big companies can afford to provide defense obligations, because that costs a lot. It's a big decision for these companies to basically take on the risk if these things happen. What will happen to small, medium-sized companies? Like if they can't afford to provide these sort of contract protections and therefore they lose market share because customers don't want to take the risk on them, what happens to that? This is not really an AI Act issue. It's kind of more just general competition stuff, but I can see how the uncertainty in IP law around AI kind of leads to that. It kind of leads to different approaches by different companies, and the dominant approach of big companies kind of supersede the market. I know that's a bit of a
Yeah.
long-winded answer, but yeah,
No,
that's what,
that's super interesting because when
yeah.
people talk about AI regulation,
Mm,
the thing that I hear most is something like, well, the EU Act is so burdensome and smaller companies are not going to be able to do all those things. But you're highlighting a different aspect of it. And this is the first time I'm hearing of this aspect. So I'm finding it really interesting. I'm hearing you say, well, because the IP laws or copyright laws and their impact on AI are so uncertain, that's why the big companies are not providing indemnity, but they do provide this like defense help. Um, but the smaller companies are not able to provide that, and that maybe harms them in competition.
yeah. Who knows? Like I could be wrong, but I think that
Yeah, yeah,
that might be one thing. And I think the unique thing about the EU is that they have this whole text and data mining exception to like the copyright stuff. So that might I think within the EU market, there's probably it's a bit, I guess, there's more clarity in the EU market around how you should use that information. But I can say in Australia and like other parts of the world, it's a bit more vague.
yeah,
But yeah.
yeah. It is interesting that some of the big companies like OpenAI are now trying to get licenses for the data they train on.
Mm.
Which is, I don't know what the motivation for that. It might be the public outcry. It might be how many lawsuits they're in. Or like maybe they're thinking that in the future it will be an issue.
Yeah, like there's a whole tension between IP and competition issues because right now we're seeing a lot of these big tech companies acquiring not well, they're either acquiring smaller AI startups to help boost their AI development, but also doing all partnerships with like content providers. So the whole deal between I think it was Microsoft or was it Google? I forgot. But one of the big tech companies has like this arrangement with Reddit. I think it was OpenAI, yeah, and they've got this arrangement with Reddit where the deal was that Reddit would license them all of their user content to that AI companies to train a model, and that became subject of the US FTC, so basically US Federal Trade Commission's inquiry investigations. So, competition regulators are looking deeply into how AI companies are trying to make all these partnerships and do all these market things. And all of this is just all because of IP issues. They're doing all these deals to try to like find a legal way to deal with the IP uncertainties in AI. And yeah, and also on the burden bit, this kind of going to another aspect, but many people say that the EU AI law is very strict and stringent, which is true on paper, but in practice, like it all comes down to the practical enforcement, right? Like it all comes down to how responsive, how effective, how resourceful the regulator is in this space. And I know there was a question on who will be the regulatory body on this. So all from the AI, from the EU level, it will be the AI office, and the AI office will have to hire people to kind of monitor that. But also, each EU country has been ordered to create a national competent authority, basically their own AI regulator to enforce the AI Act in their own national level. And they got 12 months to do that. And this is not in the official press news, but I've read commentary and just people like newsletters how the AI office is actually struggling to find people to fill the roles. Because in order for someone to work in this space, you have to understand the law and the tech at quite a deep level. And you also need to get people to move to Brussels to kind of like work in the Brussels office. So it is quite hard. And you're also competing with other companies who are hiring all this AI talent. And so you also have to compete at a salary level. So there's also questions as to whether the regulators can get the talent to enforce that. And even if they do, just thinking from a GDPR experience, regulators don't come down, giving you fines immediately. They often give you a warning first. They kind of guide you to like what you should do. Then if you don't listen, then that's when they give you the fine. The fines are pretty heavy in the AI Act, but I think I recall 7% of your revenue or 35 million, whichever is higher. I think hopefully I got the numbers right. But yeah, regulators, again, there's the practical issue, and there's also the kind of like the warnings approach before they slap you with that fine. So in that respect, I think it's not going to be immediately stringent, but it will still get many businesses to kind of like turn their minds on for this. Yeah.
Yeah. Okay. On the one hand, there are a bunch of questions I want to get to, but on
Yeah,
the
yeah,
other,
yeah.
I want to also just maybe I'll just ask you a question briefly, and then we'll get to the another question from the chat.
Yeah.
Okay, so when we think of contracts that may be influenced by the EOAI Act, so we've mentioned procurement contracts, we've mentioned due diligence processes. I mean, they're not contracts, but like close enough. You've mentioned importing, which was really interesting, and I wonder what other contracts might be influenced. For example, like contracts with employees, like HR contracts.
Yeah. Yeah. Well, one thing is like data processing contract slash addendums. That was kind of like a new thing that came out of the GDPR. Like since the GDPR, many of these big contracts need to include like a schedule or some document around how they process data. Um, who knows? Maybe with the EA Act, we might see like responsible AI addendums or responsible AI schedules that kind of outline how a vendor will comply with the AI Act. That kind of goes back to my previous.
Ah, uh, your image is frozen, and I also don't hear you. Are you with us, right? Well, I don't know if Ray is with us. Okay, well then I'll continue on the point that I think Ray was talking about. Oh, just me now. Okay, Ray's probably gonna be back now. Okay, so oh, you're back. I was just
Yeah, so I just
I
got.
was gonna yeah, I was gonna continue on the same point. So I'll just add also that you're saying there might be an addendum to
Hmm.
contracts about AI responsibility. I've already seen addendums like that, like especially one place I've seen it is with investors, right? In their term sheets. Sometimes, so investors who, for example, ESG investors or impact investors, those who already have a social responsibility interest to some degree, do sometimes include in their term sheets something about that, something about AI responsibility. And yeah, I mean, I would love, from the social implications perspective, I would love to see more addendums like that. And I think that companies would be wise to do that. One is the EOAI Act, but more generally, I think people sometimes forget that AI-enabled companies, like all companies, are still subject to the law system that still exists, right? And is not making an exception for AI. So for example, if your company is discriminating as a result of relying on an AI tool, still it is discriminating. So still it's going to maybe violate non-discrimination laws. So in many cases, you're not going to need special laws for AI, regardless of the EOAI Act. If you're buying an AHR system, even if you're not in New York and subject to the New York City, the law that I had for AI and HR systems, still you don't want to discriminate, maybe because it's socially unjust, but also because you're going to be violating the law. So yeah, I think it would be wise to add that kind of addendum to contracts.
Yeah, yeah. There's a lot of work for lawyers and professionals and consultants in
Yeah.
this space.
I mean,
Yeah.
lawyers and also, so I see, yeah, I think like two of our, like the persona of the lawyer and the persona of the AI governance person, because you really need to think about what it means to govern it responsibly. And so there are two things that you would need. Like one, you do want the outcomes. You do want to see that the system is not discriminating, right? So you might want to do an audit yourself or a third party, but also you need to be reassured that the processes through which the system is created or developed are processes that ensure that responsibility. You need to know that, is my vendor, when they're developing their AI system, do they have any metrics about fairness? Is this something that they have? Is it somewhere in their planning, right? You need that, because that's the thing that's gonna not guarantee, but increase the likelihood that the system is gonna remain its like fairness level or explainability or transparency or whatever it is. And yeah, if things are not in your contracts, then how are you going to guarantee that the vendor is going to do that, or at least compensate you if they don't, then there's a problem.
Yeah.
Yeah. Okay. Okay. We have 3 minutes, but I want to choose one more question. Do you want to choose a question, Ray, or should I?
I've extended the meeting to like half an hour. So like in case we want to answer more questions, people want to stay on for an extra 10 or 20 minutes, we can do that. Just want to let you know. We don't have to rush if people still want to listen more. Yeah.
Okay, so why don't we try to not go to go over, like if you go over just like a little bit, just like a few minutes, and then we know that we can.
Yeah.
Okay, so let's choose one last question. Okay, do you want to choose, Ray, or should I choose?
Yeah, maybe I can talk about the latest one. How many development teams have special advisors on legal compliance? Maybe Elle, if you're comfortable, maybe you can just if you want to elaborate more on your question, or you can type in the chat. If you want. In the meantime, maybe I could give a broad view on this, which is like advisors on legal compliance. So you have lawyers, you also have like consultants, but also seen a big role for privacy professionals in this space. Since the GDPR, privacy professional has become a pretty viable career. And I can see like out of all the people in my networks that, are jumping on this relatively quickly and with competence are the privacy professionals, so the IAPP sort of people. I can see them being that. And I know a lot of companies have like a good mix of lawyers, consultants, and privacy professionals. So there might be a new sort of a transition where privacy professionals, there could be like a new sort of certification or course. I think there already is where they kind of like move into the AI space. So it could be AI and privacy professionals. That could be one view. Yeah.
Yeah. Okay, so I will add that, yeah, I'm seeing AI ethics usually falls under one of the following. Privacy is one option. Just the compliance department is another option. If there's like an ethics team generally that could fall there, cybersecurity also an option. And then sometimes it is a standalone team. How often that happens, so how many of them, I do not know, because we don't really have statistics on that. In the research that I've done that I mentioned previously, it was about the last quarter of 2022. So I expect that many things have changed, but I did keep track it's from public disclosures. I forget how much it was. Maybe okay. I don't want to say just a number. But it's on my website. So you can see it there. Like maybe it was like 20%. I'm really not sure, but like I think something like that. But the two main things that companies were doing at the time, about half of them, I do remember like the two highest numbers, like about half of them were putting out like some kind of AI ethics framework or like principles or commitments or something. And slightly less, but also close to half were doing some kind of thought leadership, whether it's advocacy to regulators or like writing to the general public. So these were like the two main things that companies were doing. Some were also employing specializing, like people who specialize, but it was much, much less. The percentage was lower, which kind of also raised the question, the people who are writing those frameworks or doing this advocacy, if they're not specialists, are they really qualified? Okay, last question that I saw is, where will this video be posted? Which I think is a great question to end with. YouTube is where it's gonna
Yeah.
be.
It's currently
And
being
where
live.
it's already,
Yeah.
it's already streaming on YouTube right now. So I just want to thank everyone. It was really exciting to see this global audience. Thank you for all the questions. I'm sorry we couldn't get to all of them. but it was very interesting to see them in the chat. And we tried, even if we haven't like addressed them explicitly, to incorporate elements from those questions. Yeah, so thank you to Ray. If you want to follow Ray more, he does have a mailing list. I think it's called Alt Control Delete. Is that right?
Yeah, control plus AI plus reg. So control AI reg. Yeah.
Oh, sorry. Control plus AI plus reg.
Yeah.
Also, Ray has a really cool tracker for global AI laws. So I highly recommend checking that out. I also have a mailing list, which you can subscribe to if you go to my website, which is techbetter.ai. Also, both of us are fairly active on LinkedIn, so I invite you to follow us there. Okay. And with that, I guess have a great day, everyone.
Cool. Thank you, everyone.